Welcome to Finding the Frame. It is my sincere pleasure to welcome the former Vice President and Senior Intellectual Property Counsel of Warner Brothers, Dale Nelson, to the pod. While at Warner Brothers, Dale handled massive franchise properties such as Harry Potter and DC Comics, and she's now a partner of the leading entertainment firm Donaldson Califf Perez, where she works with independent filmmakers, documentarians, podcasters, and artists, and helps them to tackle everything from rights disputes, clearance, fair use, and the whole wealth of other legislative matters that many of us haven't even considered. So today, she'll be helping us to understand AI, deepfakes, fair use, and how parody and satire relate to it. Dale, thanks so much for joining me on the pod. So, Dale, you've dealt with two of the biggest franchises ever at Warner Brothers, starting with Harry Potter, and then you've got DC Comics. Right now, in terms of Harry Potter, you've got a TV series that's actually getting started, which goes alongside everything with a theme park and a play and all that kind of stuff. How do you deal with that legally? How do you deal with it in terms of the brand and everything like that? Talk me through it.
It's been a while. It's been 6 years since I've been at the studio, but, while I was there from the very beginning, from the day the studio bought the book rights from, the motion picture rights based on the book from J.K. Rowling, and over, probably a couple of decades, I worked, also with her legal team, and the studio to create the franchise that was created from the first book to the rollout of the 7 books, then the creation of all the movies and, all the consumer products. There were video games, all kinds of, themed events, experiences, the stage play, of course. Then there was, Fantastic Beasts and Where to Find Them. And so I think the upcoming series is just another extension of the incredible Harry Potter world. Of course, there's the Wizarding World of Harry Potter, the theme park. I mean, it's just everywhere. And for good reason, because it is a remarkable property that I think appeals to all age levels, parents, kids. And I was a parent when the first books came out, and my son was about 7 years old. And like a lot of kids, he didn't want to be mainstream because he was too cool for school. And, one day I came home because I would buy the books and like leave them around, the house. And I did come home from school, from work one day, and he was on the couch, deep halfway through the first book, and he just fell in love with it and had to sort of get over, the fact that he was interested in something that was so popular. And it was an amazing time. So he's of the first generation that grew up. And now his generation, they're starting to have children. They're passing on the love of Harry Potter. But it appeals to pretty much all segments of society. So you have a very deep and very enthusiastic fan base to develop all these businesses around. And I think the new television series just makes sense. It's just the next step.
Are there legal and brand protection concerns when you're reinventing something like that? Is there something that needs to sort of, as a legal mind like yourself, is there something that you need to protect in terms of canon or in terms of making sure that you know, keep in with the previous brand stuff that's already been established whilst also reinventing it? Is there something like that that we need to talk about?
Right. So let's talk about the legal stuff. So the main IP protection here would be copyright protection and trademark protection. And it is all based around the canon. I think Warner Brothers really made an effort to keep close to the canon of Harry Potter and stay true to the books with all the films, and I'm sure they'll do that with the series. But there's also an opportunity to explore, I'm sure with the permission of the author, uh, in all these areas. But every little symbol, every character name will have its own portfolio of trademark registrations. So Hogwarts, there'll be copyrights attached to that for the visual expression of Hogwarts Castle and all the things in it. But there will be trademark registrations around the world protecting the name Hogwarts, all the house names, Ravenclaw, Gryffindor, etc. Um, and um, and that's to protect all the businesses, but in large part consumer products, because there are a lot of people who want to make unofficial merchandise, for example, the house scarves and the colors or the banners, And so that kind of leads to an interesting question about, well, what do you do about all that, all that busy? So there's another arm of the legal department at the studio that is devoted to combating piracy, not only peer to peer, kind of, fully consumptive piracy of the films, and no doubt when the series comes out, the series, but all the unofficial consumer products. There are sometimes unofficial themed events that happen, and fans do things with the properties because they're enthusiastic fans. They're not necessarily, pirates that we think of, that have bad intentions or just trying to rip off the studio. So, one of the things I worked on a lot while I was at the studio was sort of where's this line between fan enthusiasm and think fans just having fun with the properties and things that they may be doing that may be adversely affecting the business of the studio. Um, so we had, or Warner Brothers had, and I think the other studios do too, had to come up with policies about where to draw those lines and why, and talk to fans. So there would be a certain tolerance, for example, for short amateur fan films based on the property, or certain parties, or festivals. Um, Consumer products, probably not, because, that's inherently commercial, and, it's just not right that somebody would be making money off the property by selling items where there's a thriving business for the studio to do that.
Yeah. I think we saw something not long ago with, I think it was with Charlie and the Chocolate Factory or something like that. And they did sort of a, Charlie's Chocolate, whatever the thing it was over in Glasgow. And obviously it could come under parody, but they were selling tickets to it and they were making out like it was something to do with sort of the Charlie and the Chocolate Factory style theme. Is that what you're trying to protect in terms of the legalities surrounding it? You're trying to stop people putting on things that are, Harry Potter uh, places where people can go and visit that aren't necessarily official.
Yes, that was part of it.
Okay, I understand. Yeah, that makes sense.
And most fans are, when you reach out to them, they get it. They're respectful. It's the ones that are trying to, sort of play the system, in order to make money, that are the ones that the studio would enforce against.
That makes sense. In terms of, I mean, well, I was saving this for later on in the interview, but I think we've kind of jumped onto it now, so that makes sense. What qualifies something as parody then, or satire, or somebody trying to parody a Harry Potter? Like, what's stopping me from creating Barry Trotter or something rather than Harry Potter? You know what I mean? What's stopping me from doing that? Is there is there a distinction in terms of protections there?
Yeah. So parody and satire and those kinds of questions, that's also very much a part of my practice now. A lot of independent filmmakers are interested in doing parodies of certain people or events or properties. So legally speaking, a parody is a type of fair use. Okay. Um, and fair use is an exception to a copyright infringement situation where somebody uses a property typically to comment on that property. So the leading Supreme Court case in this area involved Roy Orbison's song "Pretty Woman,"
Okay.
which you're probably familiar with, and
Oh
most people.
yeah.
And Two Live Crew did a very kind of coarse rap version of Pretty Woman. And it had pretty much the same melody, but different lyrics. It was about, the big hairy woman gets down on her knees and, but the refrain was the same, pretty woman, pretty woman. Um, I think I could be wrong about this, but I think originally they had reached out to the owners of Pretty Woman for a license to be able to do this song, and they were denied. So they went ahead and did it anyway, which you're allowed to do even if you first reach out for permission. If you qualify as a legitimate parody, then you really don't need permission, right? So, so they were sued by Roy Orbison's record company, and they defended on the ground that this was a fair use. It was a parody because the rap version of the song was commenting on the naivete and the, sort of ultra sweetness of the original version of the song. And doing the parody, they were highlighting that about the underlying song. That was a prevailing argument, and the Supreme Court gave us a lot of guidance from that decision about how parodies work and why they're important for society. And so the general rule is if you can use an underlying property in a parody as long as you're commenting somehow on that underlying work. So you can't just use a work because you like it or you think it's cool or you think it's funny, it's just, "Oh, that's Harry Trotter." Like, unless you're commenting on Harry Potter, that wouldn't work.
Oh, understood. So even if I changed the name, even if I made it Barry Trotter or something like that, I still can't because it's still referencing enough to Harry Potter for me to use it, right?
Yeah, if it's recognizable and it's
Gotcha.
going to confuse people, it sorta depends on your context. What are you doing? What is it saying? Why are you, um, triggering, Harry Potter in the minds of the public by choosing that name?
I get you. I'm always drawn to. There's a brilliant episode where Nathan Fielder, I think it's Nathan for You if you've ever seen that show. It was on HBO Max. There's one point where he wants to do a version of Starbucks, but he calls it Dumb Starbucks, and he has to prove that he's a known parody writer. He does like these songs, and he does these funny songs at comedy shows and stuff like that, so that he can then parody Starbucks by calling it Dumb Starbucks. Is that kind of what we're talking about here in terms of parody law and stuff like that? He got away with it because he could show that he was parodying what Starbucks is.
Yeah. Yeah, it's similar. It's similar, but I think that was more of a trademark infringement analysis. So you can also parody a trademark, which is, a little tricky in the law, but it certainly is possible, and there's a lot of reasons why people might want to do that. So, in that episode and I think, by the way, my partner, uh, actually cleared that episode, uh, Nathan way back when. Um, but yeah, I know which episode you're talking about. It's a great episode. And the reason, Starbucks ultimately didn't do anything was because it was so clear to the observer that that was not Starbucks, right? Call it dumb Starbucks, like, Starbucks would never do that. So what trademark law protects against is a likelihood of confusion by the public. Like, if you open a coffee shop and you call it a coffee shop and you call it, Starbucks,
Yeah, the
right?
dogs.
That might be confusing to people. It's so close to Starbucks. It's also a coffee shop, wouldn't be clear. But if you call it dumb Starbucks, people are gonna first go, "What's that?" And then they'll realize, like, that's not really Starbucks, right?
Yeah,
So that can be sort of a parody of a trademark.
I get you. One of the things that we went back and forth on, and we're moving into fair use now and everything like that, was this. There was one thing that was the Warhol case, which I think was a 2023 Supreme Court case that was involving Andy Warhol's portraits of Prince, I think it was, in the same style as how he did the Marilyn Monroe ones, and it was all to do with the Warhol estate and how this was dealt with. Can you talk me through that and how that related to fair use, etc.?
Mhm. Yeah, sure. So, unlike the Pretty Woman case, which was also a fair use case, but very specifically on parody, the Warhol case didn't involve a parody, but it involved a different kind of a fair use defense. So, in the in the and it derives from the Two Live Crew Pretty Woman case. In that Pretty Woman case, the Supreme Court talked a lot about the importance of transforming the underlying work into something new that gives it new meaning and message. Like you're using the underlying work, but in the rap version, the parody version, they transformed the underlying work into something new with a new meaning and a new message. That's what courts now refer to since that case as transformativeness. Okay. So that's a very important concept now in any kind of fair use case. So in the Copyright Act is where you find the fair use defense. It's a statutory exception that is mentioned in the Copyright Act of the United States, and it's in Section 107. And what Section 107 says is you can use a copyrighted work without the permission of the copyright owner if it falls under fair use, and fair use shall be determined by balancing these four factors, among others that are relevant. Okay, and so in the fair use jurisprudence, you will find that the judges always talk about these four factors in order to determine whether or not the use of the underlying work is fair. The first factor is what's the nature and purpose of your use, okay, including whether it's transformative. And as I mentioned before, transformativeness comes out of the Two Live Crew Pretty Woman case. The concept is, are you using the underlying work to transform it into something with a new meaning and a new message? Okay. The second factor is, what is the copyright level of the underlying work? And what they mean by that is if it's a factual work, like you take out your phone and you snap a picture without really any creative input, it's just a sort of factual work and it has a lower level of copyrightability. And if you write Harry Potter, a highly creative fictional story, that deserves a very high level of copyright protection. Third factor is how much of the original work are you using? Okay. And that really varies based on your purpose. Like in the Pretty Woman case, they use pretty much the whole song. But in the balancing the factors, generally speaking, the shorter the 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 less you use, the better. And the fourth factor is what's the effect of your use on the market for the original. Okay. So in the Warhol case, it's sort of an unusual case because it's very clear from the procedural posture of the case, the pleadings of both parties, and what the court says is that they were only limiting their review to the first factor. Okay. The nature and purpose of the use, whether it was transformative. Um, and so, what was interesting about the Warhol case was that traditionally you would just look at the secondary work. You would look at, okay, Lynn Goldsmith took this photograph of Prince, Andy Warhol took the photograph and transformed it, they argued, into this highly creative artwork. And the Supreme Court kind of put a new twist on that. They said, well, that's not the end of the analysis under the first factor. They said, we need to look at the actual use to which the secondary work was put. And under the facts of the case, they felt it was very important that and significant that the Warhol artwork was used on a cover of a magazine to illustrate an article about Prince.
Okay.
So they compare that use, right, to Lynn Goldsmith's use of her photograph of Prince, which was also used to illustrate a magazine article about Prince. And so, under those facts, the Supreme Court sort of went, oh, Lynn Goldsmith's use of her photograph was to illustrate an article about Prince in a magazine. The Andy Warhol artwork was used to illustrate an article about Prince in a magazine. It's the same use. So, in that sense, they found that the use was not transformative.
Even if the magazine was different, even if one was for a fashion magazine, say, or a music magazine, and the other one was for art or to show something, like a Sotheby's style magazine, something like that, would that still constitute not transformative?
Well, that's a good question because in under the facts of this case, the magazines were generally the same. I think, you know, Lynn Goldsmith was known for like illustrating articles about lots of musicians in like Rolling Stone and magazines like that. The Warhol artwork, I believe, was on the cover of Vanity Fair or some Condé Nast publication. Similar enough. But the Supreme Court did note in the opinion that the outcome might very well be different if the Warhol artwork were featured in an art book, okay? Or if it were hanging in a museum, okay? So with that, you really understand now the meaning of transformative use has a little bit of a different meaning than it did prior to this decision. But in the normal set of facts that we usually work with documentary filmmakers, for example, you don't have that kind of side by side similar use that arose in the Warhol case.
That was gonna be my next question. Well, how does with this legal understanding that we've just gained now, how does fair use work in terms of documentaries, in terms of scripted films? And how has the bar changed, I suppose? Has it got higher? Has it got lower over the years based on these Supreme Court rulings?
Yeah, well, I think that because of the Supreme Court's rulings and just the dissemination of knowledge about fair use, reliance on fair use has become more commonplace than in the past. I think filmmakers were afraid to utilize fair use in the past because, maybe certainly 30 years ago, maybe 20 years ago, because it really wasn't that well known. It wasn't really that accepted. And so the more people were using it, um, then of course the more the cases were litigated, but a lot of fair use defenses were prevailing. So I think filmmakers are more comfortable now. Also because thanks in large part to my law partner, Michael Donaldson, insurance companies started to write policies covering fair use maybe about 25 years ago, 25 years ago. And now it's very common. We write opinion letters on fair use all the time for both documentaries and narrative films and all kinds of different art projects and things and books and the insurance policies will readily issue these policies. So once the policy is issued, then the filmmaker or the artist can feel more comfortable in taking their film out to the market. And if they get a copyright infringement claim, they know that worst case scenario, the insurance company will defend them. But I'm getting a little away from your question about Warhol. But I did want to say that, a lot of lawyers and certainly filmmakers and others were kind of concerned after Warhol came out. What does this mean? Is this the end of fair use? I don't think it has as much significance as people worried it would because the decision is so limited to its facts. And as I was saying before, you don't normally have uh, the uses of the end of the secondary work so close to the uses of the underlying work that was fact pattern in that case. You just don't. So, say a documentary filmmaker wants to use a clip from a motion picture in their documentary about an actor. Okay. Using the clip in the documentary is a very different use than the original use of the clip, which is part of a motion picture that people would go for entertainment purposes, right? So the uses are very different.
Would I still not need to pay for that in terms of, using those clips or anything like that? Would I still not, or can I use them because they're fair use?
Well, you'd need to get it evaluated by a lawyer like me, in order to feel safe that it did fall under fair use, because fair use is a legal conclusion. But I would say, yes, that's a classic scenario. We work on documentaries all the time about actors or, the making of a film, for example, where you will necessarily want to use clips from the subject that you're talking about to illustrate the points in the documentary.
Well, one of the things that we've been doing, and one of the things that we used to do at Filmmakers Academy, we used to make a show called uh, The Look Of, and it used to look at these different films and would break down how the director or how the cinematographer had shot a certain shot or had used the camera in certain ways or anything like that. And that involved us using, not necessarily elongated clips from the film, but certainly longer than, say, 20 seconds, possibly 30, 35, 40 seconds worth. And then every time we've done it, including just recently with The Brutalist, we had somebody who was actually on the podcast talking about their shots from The Brutalist, the shots they'd shot. And when we used it in the video of this podcast like this, it was immediately taken down. Like, we were told by Instagram, by YouTube, by everybody that we couldn't use it. That we weren't allowed to have that clip on there, even though it was used in a podcast sense like this, or even though it was used in a, almost a video analysis sense, not used in the entertainment sense like The Brutalist is a film itself. So would we have been covered by fair use in that respect or not?
It sounds like it. It sounds like you would have been. Yeah, we work with podcasters all the time with this kind of thing too. I mean, usually it's an audio clip, but more commonly now the podcast is videotaped like this. So if you want to use a visual clip, um, yeah, I would say, as long as there's commentary on the clip and you're just using the clip to illustrate the points that your commentator is making, and you're not using too much, you're just using an amount that's reasonably necessary to your purpose, that that is a fair use. Now, I'll mention, if you do get a takedown notice, there is a procedure called a counter notice where that you can file in response and say, I'm using this pursuant to fair use. Um, and then the platform is obligated to put it back up.
Would you recommend filmmakers like myself or like the people who are going to listen to this podcast, would you recommend that to ensure that they're covered by fair use, they consult somebody like yourself, like a lawyer, and get an opinion letter or something for insurance purposes and for if they get things taken down like this?
Yeah, I would. hmm And that's why filmmakers come to us. So the process is basically, you engage our firm as a filmmaker. We would sometimes have a preliminary discussion with the filmmaker so that they understand how to put the film together and understand fair use, generally speaking. But then they'll come back to us with a rough cut and a clearance log listing out all the unlicensed materials, whether that's a clip, a photograph, an audio clip, a newspaper headline, all those things. Murals and other artworks fall into that. And then we will review each use, give him advice on, what needs to be licensed or changed, or what we might say, this needs to be cut down. And then we might say, you need to change the commentary here, or there's not sufficient commentary here. Uh, and then there'll be some revisions. And then at the end of the process, which sometimes, takes a few rounds, we'll write an opinion letter, assuming we believe everything is legally sound. We'll write an opinion letter and sometimes put the client in touch with an insurance broker if they don't have one. Then they get a policy and away they go.
Yeah. And that's E&O insurance, right? That's the thing.
Insurance with a specific fair use endorsement on it.
Copy that. Yeah. Is there any merit in putting either at the beginning or in the writing on, say, it was YouTube, in the sort of description or anything like that, no copyright infringement intended or anything like that? Would that carry any weight, or is that just kind of like hopeful?
Well, Let's use YouTube as an example, right? They have, what do they call it? Sorry, it's been a while, but they have, each film studio, how about the majors now, and others who choose to engage in this, they'll um, they'll have a system that they work out with YouTube. This amount of material isn't enough to worry about, but if it exceeds this length, um, and sometimes there's an audio video visual match. Content ID system. That's what I was thinking of. So, I mean, sometimes these rules are automated, and so um, if there are bots on the internet looking for certain things, that could trigger an automatic takedown. Now, now most studios also have built-in safeguards to accommodate for fair use, right? They'll either review everything, manually and make decisions about whether things are fair use, or they'll have, sort of a bucket of rules saying, well, this might be a fair use if it meets a certain criteria, so we're not going to trigger a takedown with that. So I'm a little surprised that, that you've encountered that in what you described, but it does happen, and fortunately, there's a way to respond to that.
I was gutted, Dale, because one of the videos that we had, I think it was when Joker came out, which is obviously a Warner Brothers DC property. And we did Joker, and it was Todd Phillips's film, obviously, with Lawrence Sher as the DP. And I'd done a whole breakdown with my friend Ross, who was an editor, of how they shot it, the way they gave headroom in certain shots, the way that they closed in on it. And it was just talking about the way that they filmed the film, really. And we took every clip pretty much from the trailer because we didn't have access to the full film itself. We weren't going to just copy it off the internet or find a pirated version. We weren't going to do that. We used the stuff that Warner Brothers put out to show what we were talking about. And yeah, I think it was within, and I mean, we had 250,000 views within a week, I think, or maybe a couple of weeks. So it was doing really well. It was doing some good numbers. We hadn't monetized it even. It was free use, you know what I mean? It was just for anybody to look at. And then, yeah, it got taken down fairly quickly after that, and it was gutting because it was one of those where it could have set us up for further things to do in that kind of vein, I suppose. And it certainly put the wind up us and made us kind of question what we were going to use in future, whether we were just going to use a still picture to talk about things rather than the video itself. So it became very kind of prohibitive. So I think that that's something that's, I'm grateful to you for answering that, because obviously there's a lot of filmmakers, I'm sure, who are going through the same kind of process right now, you know?
Yeah. So I would say, if you feel like you have a strong fair use position, then there's no reason not to file a counter notice, and then maybe you can have a discussion platform about it.
Yeah. In terms of clearance and things like that, then what are the most commonly overlooked clearance items that can delay, or even, I'm talking about a film distribution deal now, so something like a documentary or something like that. What are the clearance items that people often overlook that they don't think about? Is it stuff like having stuff in the back? Like, you'll like how I set this up, Dale, for you. I everything that could be a clearance nightmare. I've got like Aquaman up here for you. I've got Jaws. There's a Star Wars thing here. I even nearly wore a T-shirt with something on, maybe Ravenclaw. So, like, anything like that, is the things that people overlook with in terms of clearance that can kill a film's distribution deal if it's not handled in advance?
Yeah. That's a great question. You know, and we represent a lot of filmmakers, and many of them are very experienced, and many of them are not. So, I'm kind of mindful of the first time filmmakers, or ones that haven't learned the hard way, let's say. Um, and yes, I mean, artwork in the background is definitely one of those things, because um, most things will have some copyright attached to it unless it's in the public domain. Now, you kind of have to break it down and work in a pragmatic way as well. If somebody's shooting in an apartment and there's something on the wall that they just got at IKEA or whatever, and it's sort of mass produced, it would be impossible to sort of track down who the copyright owner is, and the risk is probably very low. But, in contrast to the IKEA piece, if there's a very distinctive, unique piece of artwork, and particularly if the shot was framed because the filmmaker liked that artwork in the background, that's going to be a problem. And if you don't realize that that's an issue early on and everything gets shot and it could look really ugly to blur it, um, you're going to have to go out and try to get permission from the copyright owner. And then what if they say no? You know, or they may have a lot of leverage over you at that point and they demand $1 million. It's just that kind of thing you want to avoid. Murals are a problem, or not a problem, but an issue that comes up in this context a lot because people will be filming on the street. Again, they'll say, "Oh, look at that cool mural over there. Let's move the actors over there, and we'll shoot the dialogue so they're standing right in front of it." That is a problem. Why? Because you're using it for its artistic purpose, which is arguably the same purpose as the original artwork, right? And it's copyrightable. People don't think about that, but somebody drew that mural, and so we usually advise our filmmakers to reach out if we see a mural in any shot because it's usually used for its beauty and not because it relates to the subject of the film. Now, if it's a film about murals, then that's completely different. If it's a documentary about murals and you're kind of going around and, you have an expert explaining each piece, then you're entitled to show it because there's a lot of commentary there. So ironically, there you probably wouldn't need permission, but it's still risky. Mural artists probably don't have a lot of other income, so there's also that, so kind of that ethical consideration, like, shouldn't you be paying them for their beautiful artwork that I now want to include in my film?
Yeah. I worked in scripted television at one point, over at Sony Pictures, and one of the things that we had problems with was background extras and things like that with tattoos. And I never even thought that that was a clearance issue, but it became something you'd have to cover all. It was always a question they asked, "Do you have tattoos?" And then as soon as people said yes, then they would be in the makeup chair, literally having it covered up. Now I know that it was kind of possibly for aesthetic reasons as well, but primarily they were saying it was for clearance. Can you talk us through that? What is it about the tattoo that makes it a clearance problem?
Well, it's sort of like the mural. The tattoo itself will have is an artistic work, just happens to be on the body of a person. So technically speaking, if you're taking a photograph of the tattoo on someone's arm, it's really no different than taking a photograph of the artwork hanging on the wall, right?
Wow. Yeah. Even if the person whose tattoo it is, they've paid for it, it's their tattoo and everything like this, it still comes back to the artist of the tattoo.
Well, that's the difference, right? So there is an argument of kind of implied consent um, that has been successfully litigated, I think, in one of the video game cases where they showed basketball players and they reproduced them in avatars and they wanted to identify the player. They had the permission of the player, but not of the tattoo artist who put the tattoo on the player, but they showed the tattoo of the player. And I think the successful argument there was, look, when you get a tattoo, there's an implied consent by the tattoo artist that the person wearing the tattoo is going to then go out into the world and be photographed. And there's got to be an implied consent to that. So I think that's the right rule. A lot of lawyers would argue otherwise, but I think that's the right rule. The same thing should apply to like jewelry or clothing or things like that, which theoretically has some copyright attached, depending on what the item is.
On clothing and branding and stuff like that, is it something like if I'm a documentarian and I'm going out filming, should I be watching out for people wearing logos on clothing or anything like that? Or is that something that I'm okay with in a documentary, but in a scripted sense, it becomes a bit more complex?
My opinion is it's okay in both situations. So that really calls into question again the difference between copyrights and trademarks. So brands are going to be There could be some copyright attached, but it's primarily a trademark issue. And as I mentioned before, the trademark law really protects against a likelihood of confusion that somebody's going to be using a brand and the consuming public will think it's the other brand, right? So, but if you're just wearing like a Nike t-shirt in a film, nobody's going to think anything about Nike. They're not going to think, oh, this is a Nike movie, right? They're just not going to think that. And Warner Brothers actually made some great law in this area during the time I was at the studio in a case involving one of the Batman movies where one of the plot lines was involved a computer program called the Clean Slate program. And I frankly don't remember I should embarrassingly, I don't remember the plot line well enough, but I think it involved Catwoman and she was going to use the Clean Slate program to save the world or destroy the world or one of those two things.
I think she was going to clear her background as a criminal, so
Thank yes,
then she could live a clean life, I suppose you'd call it.
that makes sense. Thank you.
Yeah.
And it was from Batman Returns.
The Dark Knight Rises, I believe it was. So the final one of the Christopher Nolan trilogy. Yeah, no
Okay,
problem.
you know your Batman.
Big fan.
Yeah. So you'll be interested then. So there was a business software company that had a product called Clean Slate, and they actually brought a lawsuit against the studio for trademark infringement. And the court wrote this wonderful opinion that just clarified once and for all, look, this is a fictional movie about a fictional universe full of villains, and everybody seeing it knows it's not real. And nobody's going to think that it's your software program that's the plot device in this movie, nor is anybody going to walk into you know, your your business software store and say, "Oh, I want that program because it's the one from the Batman movie." And it took litigation and a court opinion to point that out, but it's a great opinion because it goes right to this point that people worry about, and I think filmmakers worry about it too much. And I've seen things where they'll tell people to put their shirt on backwards or, don't wear that hat or, something like that is absolutely unnecessary.
Wow. Final thing on clearance, really, in that respect. Then, so how does clearance and clearance standards shift from, say, film festival? Like I've taken a film to film festivals and stuff like that, and I've been told in the past that once you go from film festivals to, I don't know, streaming and possibly, I mean, mine's never made it to theatrical release, but theatrical release and then international sales. How do clearance standards change? Do they change? And how do they change?
Well, they don't really change through the process of distribution. It's not like you get a free pass just because you're at a festival. Um, which some people, sometimes filmmakers ask me that. They're like, "Well, we're just at a festival," and I'm like, any exploitation is going to expose you to a claim, right? Excuse me. And so, the laws don't change just because you're at a point in the distribution of your film. Now, if you're talking about distributing in different countries, that's a different question because every country will have their own national intellectual property laws. Generally speaking, they're going to be the same. But sometimes there are differences. So, for example, throughout the EU, if you want to rely on what they call fair dealing, which is like the equivalent of fair use, the standards are a little bit more conservative. So you want to be a little extra careful there, but it's still possible. But you have to provide attribution to the copyright owner in order to qualify under fair dealing. That's not a requirement under United States fair use law. So we always advise our clients, look, in the normal course of distribution, you're going to want to distribute this worldwide. you might as well follow the European rule, provide the attribution, and and away you go. So,
That makes sense. I lived and worked in Turks and Caicos, this little island in the Caribbean for a little while, and they said there's no copyright law here, so you can use any songs you want, anything like this, and I was like, yeah, I was trying to stick to the fair use of the whole world really in that respect, but yeah, on Turks and Caicos they were a little bit more like just throw anything into any of the things you film. You can use any song. You can use the Beatles if you want. You could use the Rolling Stones, because like these videos were purely for hotel TV on Turks and Caicos Islands. You know what I mean? So that was. I mean, they might have been lying to me, Dale. They could have been telling porkies. In which case, I'd be in a bit of trouble now if those videos all came out, because I certainly did enjoy myself with the musical choices.
mm,
So moving the conversation on now to what I'd originally planned to do first, but I think it kind of organically reached here. Looking at AI and deepfakes and the way that the world's going right now, because it is quite a minefield that nobody really knows what we're stepping into right now. Can you talk us through, for anybody who's been on Mars, what a deepfake is and how it relates to our industry? And we'll go from there, I think. But tell us, first of all, what is a deepfake for anybody who's been living under a rock?
okay, so deep fakes. Deep fakes is an interesting term because I think it means different things to different people in different contexts. Um, but when people think of a deep fake, they're usually talking about a situation where somebody has made a digital replica, which is another term people use, of someone, and they've put it into a context where the person wasn't really there, right? So this happens a lot with pornography. Okay. So many celebrities have and normal people too have a real problem with bad actors who will create a deep fake of the person's face or sometimes their body too, engaging in pornographic acts, and it'll be circulated in a somewhat underground internet space wherever those videos live. I actually worked on a fascinating documentary. I'm going to make a little plug for it here. It's called Another Body, by a great production company called Willa, Willa. And this was a few years ago, and it was a film that premiered at South by Southwest. And it's about the victim of some pornographic deepfake activity by a woman who this happened to her while she was in college. And she wanted to tell her story, to warn, to, talk about it and make people aware that this is a real problem, not just for celebrities, but for anyone. And so they made a documentary about her experiences, but her and all the characters in the story and telling the story, including the perpetrator, were done using deep fakes. So it's a really interesting way to tell the story using deep fake technology, partly because she wanted to remain anonymous, but partly to just kind of highlight the power of the technology. And then it's a whole story about how she was in college, she was a computer scientist, so she sort of understood the internet, and somebody flagged to her one day, "There's this porno of you going around," and she looked at it, and she got her friend to help her, and they decided they were gonna hunt down, they were gonna figure out who was this, which they did. And, you know, not to spoiler alert the film or anything, but one of the sad points of the film and the reality about those kinds of deep fakes is there are criminal laws prohibiting it, but it's really, really hard to enforce. Okay. Police departments have no clue, and like, they some of them, maybe the better funded ones, might have a cyber squad that could tackle something like that. But typically, the deep fakes are posted by people who are doing it anonymously. They don't want to know who they are. They're being consumed by people anonymously. Um, And it's just, it spreads without any accountability or anybody to arrest, right? I mean, there are people behind it, but it's just really hard to track them down. So that's one area of deep fakes. That's not really my area of practice. There are criminal lawyers that deal in those kinds of things. Um, what's more relevant to my practice is, the not so dark side of digital replicas. And that's where we typically use that term digital replica instead of deep fake. Because to me anyway, deep fake has sort of a connotation of something bad and devious. So, whereas a digital replica is like, I could recreate you. I couldn't do it, but someone familiar with AI technology could recreate you or me using AI. And these days, it's not that difficult, right? Or they could recreate President Obama or whoever they want, in a video saying things that he never said. We've all seen kind of example. Um, so again, there are criminal laws and laws against fraud generally. There doesn't really have to be any new kind of law, but if you misrepresent someone and you do it in a defamatory context, then they could bring an action against the maker for defamation. But again, sometimes you don't know who the creator is, and enforcement is the difficulty. Now, in the entertainment law space, there are kind of other aspects of the use of digital replicas. One is something that the SAG actors have now successfully negotiated in their guild agreement, so that if an actor is scanned by a studio and a digital replica of them is used, it has to be done with their consent. They have to be paid. And there's a lot of guild rules now around SAG actors um, in that context. And that's fine. But there are also exceptions there for free expression and things that are protected under the First Amendment. For example, parody, that we talked about earlier. Or there'll be an exception for using a digital replica about a person in a biographical film. I wanted to say whether that's a documentary or a narrative film, even if there's some degree of fictionalization, that's considered fair game to use a digital replica, just like you'd use an actor, to play, I don't know, JFK or President Trump, in a film. And so when you think of it that way, it makes sense why. Because if you had to ask the person's permission to portray them in a film, either using an actor or an AI digital replica, then you might run into a free speech censorship sort of a situation. Then the person could say, no, you can't tell my story. And that's not right, because the First Amendment protects everybody's right to talk about real people and real events. And if you had to get the person's permission, then you wouldn't be free to do it. It would chill speech, right? So there's those kinds of protections that are built into those laws. Um, and you see the same thing in the right of publicity laws. Now, the right of publicity is a aspect of intellectual property that we haven't really talked about yet today. So the right of publicity, these are state laws, not federal laws. And they generally protect against someone using someone's name or their likeness or their voice, sometimes their signature, for a commercial purpose, right? Typically, is to protect against using, I don't know, let's say Arnold Schwarzenegger's likeness to promote a car, you know? Um, somebody shouldn't be able to make a digital replica of him was the thing he used to say that that there was the girly car? The
Oh,
ele
yeah. I know
the
what you mean. Yeah.
yeah, what car was
I
it?
can't remember the film it was in.
One of the early hybrids.
Yeah.
So
I know what you're talking about.
I could see somebody saying, "Oh, let's try to sell the car." We'll have Arnold Schwarzenegger come back and say, "I changed my mind and no longer think it's a girly car," whatever.
I get what you're saying.
That
Yeah.
would be using him for clearly a commercial purpose. His name, his likeness, and that's prohibited. But if you're telling the biography of Arnold Schwarzenegger, um, that falls outside the ambit of the right of publicity.
Okay. So even if it's an unauthorized biography.
Right. Really, you don't need his permission
Gotcha. Yeah.
because, again, to require his permission might mean that the film never gets told or it gets told his way, right?
But because he's a public figure, I can do it and I can use his likeness to help tell the story of Arnold Schwarzenegger without his
Yeah,
permission,
you don't even
effectively.
have to be a
Okay.
public figure. You could do it about anybody. So, so that's the distinction between expressive works like books. People write the unauthorized story all the time, right? Or movies or TV shows about real people. Um, and commercial works like the car advertisement or, putting somebody's face on a t-shirt and selling it. You can't do that without their permission. So, so that's the right of publicity, and it's been like that. I mean, not without some litigation challenges, but it's been like that for many years. And when I was at Warner Brothers, I worked on a very seminal case about this involving a movie called The Perfect Storm.
Oh, yeah.
Remember
George Clooney and Mark Wahlberg. I
right?
remember it very well, yeah.
Yes, you know your movies. So that was based on a true story. Um, Told the story of these fishermen that went out to sea off the coast of Massachusetts and they met the tidal wave and no one lived to tell the tale. So to make the movie, you necessarily had to make up dialogue and interactions, what went on the boat, no one really knows, right? And so surprisingly, what happened was the families of the deceased fishermen sued the studio for a right of publicity violation. They said, "Oh, you used their name and their likeness. Yeah, it was George Clooney and Mark Wahlberg, but they were supposed to portray, our relatives." Um, and they sued for right publicity violation. Why? Because they couldn't sue for defamation. One, because the people were dead, and when you're deceased, you have no longer have any claim for defamation. Um, And so but the right of publicity does survive death for a certain period of time. So they said, well, we're going to sue for right of publicity. And Warner Brothers said, no, 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 no. This falls outside the scope of a right of publicity claim. And that was sort of a new theory at the time. Nobody had really challenged that before. There were a couple of cases. Um, so they litigated it and it went up and down on appeal a few times. And ultimately, the court did the right thing and basically said, this does not fall within the right of publicity statute because it's an expressive work, it's a biographical film.
What's the potential for defamation on this? Like, say I do a biography, this fictional biography that I'm going to do of Arnold Schwarzenegger, right? And I do all these sort of not necessarily deep fakes, but the term you used was much nicer. I mean, these digital replications, I suppose, of Arnold Schwarzenegger. If I portray him in a way that is, like there's certain points in it where it's contentious, could he have could he potentially have me for defamation? And another thing on the back of that is there a risk there of misleading audiences that they think they're going to see a film that's starring or has got Arnold Schwarzenegger in it, but actually it's just me doing a digital replication, I suppose?
Well, that's a great question. So the right of publicity laws that contain now special provisions for digital replicas and have exceptions for biographical films, to put it simply. As I said, it's state laws, so they kind of vary in their details, state by state. And the New York law, I believe it is, which only applies to deceased persons. So there's sometimes distinctions between the rules for living people and the rules for deceased people. But the New York law does have a kind of a misleading, don't mislead the public requirement. So as long as you put a big disclaimer up and you say, this is not really Arnold Schwarzenegger, playing himself in this film, then that should satisfy that requirement. But I think most people are going to kind of know.
Yeah, Black Mirror did a great. If you ever watched Black Mirror, that's on Netflix. I don't think it's this season, but certainly last season they did a fantastic episode that had Salma Hayek in it, and it was all about like they created a digital representation of Salma Hayek playing a woman in her life. You know what I mean? And it went through this whole thing of whether Salma Hayek was involved in it. It was a really really clever episode the way that they did that. If anybody wants to see it, I think it's episode 1 of season 6 or whatever, so they can
Yeah,
give
I'm
that
gonna
a
have to
view. But
watch that. I had heard about that and hadn't seen it. So
it's fascinating. I won't give away the end or anything like that, but it certainly goes down this route that we're talking about now in terms of deepfakes. And that's another thing that I was going to bring up actually. So deepfakes have been used to de-age actors. We've got people like, I mean, one of my favorite films, like The Irishman. You have, Robert De Niro and Pacino and Joe Pesci. They're all de-aged using, I wouldn't say deepfakes, but certainly new and certainly getting newer technologies, but also bringing it to my question, resurrecting deceased performers like Marlon Brando in the new Superman film, or Christopher Reeve in the new Flash film, which are all DC properties. How does that work when you're bringing back somebody like Christopher Reeve to actually be Superman in the Flash, digitally? His family didn't sign off on it. Nobody signed off on it. It was just purely they put him in so that it could be almost an Easter egg for people watching. Is there a legality surrounding that, or is that fair use?
well, I think this gets into these new digital replica laws around the right of publicity um, that we've been talking about. So some of the laws are going to apply to living persons and some to deceased persons. And sometimes the motivation behind the law is they don't want they don't want a studio using a digital replica in place of an actor that could have done the job, right? So that employment kind of concern doesn't really apply if the person's deceased, right? And it doesn't really apply if it's a biographical film about the person who probably wouldn't be playing themselves, right? So it gets a little complicated, but I think that where you have where you have a situation that you're using a digital replica of an actor, to play the role that the actor would have played had you not, replicated him, that is what these laws are addressed, are written to address. So it's normally you would want to get the state's consent, or if they're still living, the person's consent for something like that.
I get you. We've got these things. I mean, like this is what's crazy right now. We've got in the film industry right now, the studios themselves are actively funding, sort of new developments in AI and new developments in deepfake technologies. We know Disney Research Studios are currently working on a deepfake model, and there's filmmakers out there who, knowing that it's cheaper, and like I can't disagree with them, it is cheaper to use AI. For certain things, like James Cameron's talking about using it for Avatar. Not sure if that's a Warner Brothers property or whether it's another studio, but it might be Disney. But he's talking about using AI in the latest Avatar movies and things like that. Surely that takes things away from people who are working. So are there labor laws regarding that? Or is it something that we're just so far behind in terms of the litigation? They can do it, and it's sort of like, it's better to ask forgiveness than permission, I suppose, in this respect right now?
Well, yeah, I think in the film industry, the actors certainly were ahead of this. by negotiating these new rules in the SAG agreement. So, that they've got some protections now. In any other profession, I mean, in the legal profession, I mean, AI is taking over things in my realm as well. I mean, everywhere you go, AI is going to replace somebody or some computerized version. So, look, I mean, AI is here. It's not just coming anymore. It is here. It's involved in every aspect of our lives, frankly. And so, to try to stop it because it's going to replace people's jobs or put people out of work, I think is just, I mean, we've had other technologies that have done that. In filmmaking, I mean, movies were made before CGI, right? And set workers are probably put out of work because of, or prop masters, or those kinds of examples, right?
Yeah, I think that my issue with AI though is that it's effectively a copying tool, right? I mean, like it takes what's been fed into it and then it copies it or it finds ways to manipulate it. And my worry is that what we're going to end up with is a lot of things that look very or not necessarily samey, but certainly things that have been copied from things that have been fed into the AI. So therefore, what you're going to end up with is VFX that's been copied. Do you
Yeah,
understand?
I do. And there's a lot of, practical and legal and ethical questions about AI sort of swimming around in the film conversation these days, And one of the things I wanted to mention, because a lot of people probably don't know about it, is there is a best practices toolkit and set of guidelines that's been put out by the Archival Producers Alliance, the APA. And it's, specifically directed to documentary filmmakers. But it raises a lot of interesting points and I think good advice for a lot of other kinds of filmmakers as well. But it's really relevant for documentary filmmakers. So, they go through, and you can find them at the website, the APA, Archival Producers Alliance. And their concern is uh, documentary filmmaker documentary filmmaking in large part involves, a historical record or an exploration of things that have happened in the past. And they use archival material to do that, right? Whether it's an old clip or a photograph. And, AI can be used to maybe clean up that photograph or make it color instead of black and white, or, in the worst case, turn it into a audiovisual work where somebody's doing something they didn't really do, right? These are all kind of unethical practices that they want to warn against. And one of the points is, like, AI machines only scrape from what's on the internet and what's digital now, and that leaves untouched the real historical record of the world in our lives, which is in large part undigitized, right? So if you're going to say, well, let's create the scene and the civil rights movement in, 1969 in this event, and they want AI to do it, it's not going to be, historically accurate. Um, and so, just kind of considerations like that, how to inform your audience about the use of AI in your film, um, important disclosures that you might need to make to your insurance company, to your distributors. Ask your distributors, do they have policies against AI? Are they okay with AI? How are you going to keep track of everything? They recommend tracking methods for things like that, and we do too now, because um, well, it gets into copyright concerns too, because the Copyright Office and courts have confirmed their opinion that if something is created using purely AI, it's not going to be copyrightable, because to be copyrightable, it requires some human authorship. some human creativity. So there's a big debate now about, well, what about the prompts, that you use to create the AI, and how much, and and this and that. So that's still being worked out, but it's fairly clear that if you're using only AI to generate an artwork, for example, no copyright will attach to it.
It's happening now. I'm seeing advertisements for films that are going to festivals right now that are entirely AI. Like, the people want, there's people out there who want the first fully AI film and stuff like that. So this is fascinating to me to hear.
Yeah, I'm not sure why that would appeal to anybody, but
Doesn't appeal to me,
yeah,
no.
people used to want the NFTs too. So,
They disappeared quick, didn't they?
right.
The last thing I'll ask about is, and it's something that I saw recently, there was I'm not sure if you saw it, but it certainly came out on all my socials. And it was people, once they realized that ChatGPT could create images or was able to create images, which is recent, they were doing versions of themselves in a Studio Ghibli Hakeo Miyazaki style, which is, this style of animation. And people were putting in pictures of themselves. People were taking pictures off the internet. There were well-known memes or anything like that, and they were doing it. Was there any legality to? I mean, like I remember Studio Ghibli sending something out saying we're absolutely appalled by this, but there's nothing we can do about it. And I thought to myself, I imagine if that had a certain, mouse on it from, let's call him Wilt Dosney, just to kind of protect my back here. But if we had certain, other elements in there, would that then be protectable, or would that be something that would be able to be shut down through ChatGPT or not? You know what I mean? What do you think?
Well, yeah, I'm not entirely familiar with all the relevant facts here, but it's people are creating videos using the style of the studio.
Yeah,
Uh,
so an animation style that is specific to one studio, specific to one artist himself, actually. So it's like taking, I suppose, like the Disney style of drawing things, like, you Snow White and Seven Dwarfs style animation, and they're attributing it to other things and other pictures and other things like that. And Studio Ghibli are very upset about it, and they've put out posts and things like that saying that, but they've said we have no protections against this. We just have to, shake our head, I suppose.
yeah, it's a real shame. I mean, it sounds like yet another, new form of piracy, yeah, that studios have faced for, 30 years, right? And it's like weeding a garden, you never get rid of it all because the internet is so full of it. But I mean, theoretically, if the output is substantially similar to something that the studio created, that would be a copyright infringement. If the created videos are promoted in a way that misleads people to think it came from the studio, that would be a different kind of a claim. Um, but, you know, enforcing stuff on the internet is, like I said, a thankless, never ending task. Um, so, some point, I think IP owners just need to realize that and just be comfortable with a certain amount of piracy.
I think that leads to probably my last question, which is talking about, are we too far behind on the litigation of this? You know what I mean? Is this something that we probably never will be able to litigate with the speed at which the internet creates things and moves on? And, it's a little bit like a scattergun approach, I think, is the way they talk about it politically. Once something shocking happens, or something that is piracy or something like that happens, there's so many other things happening for us to be able to litigate. Each and every single one of them would be tied up in litigation for decades, centuries even.
Yeah. Yeah, it's always a game of whack-a-mole, right? So I'm I'm old enough to remember, practicing law before the internet, if you can imagine such a thing. And it was very different then. You heard about, well, first of all, you didn't hear about all the infringements, right? It was probably going on, but you wouldn't necessarily be aware as an IP owner. If you were, you'd have your lawyer send a cease and desist letter and the problem would be addressed, right? Um, but with the internet, like everything changed because it was just multiplied everything a billion times. So I think, most IP owners that can afford it have big piracy departments and all kinds of mechanisms to address the problem so that at least they can continue doing business, right? But again, you'll never get it all.
It's absolutely fascinating, Dale. And as I said, I could talk to you for hours on end. And
Oh, I could talk about this all day. Yeah.
it's a bit. I mean, one thing I will say, when I worked at Sony, I met this person. This is a great story. Do you remember the show, the film Jerry Maguire?
Yeah, obviously. Yeah. And I know the lawyer who was in it.
I think his name was Jared Jussim.
Yeah, I know Jared. He's a friend.
I met Jared when I was having my car serviced, when I was down at Sony, when I was working there, right? And Jared was in doing some kind of lecture, or he was talking to somebody. He's like there as a sort of honorary vice president or whatever it is. And Jared told me that the reason why he's in Jerry Maguire at the beginning is because he went to Jim. Do you know this story? Am I telling you a story that you already know?
Tell the story. You know the details.
He said and he just volunteered this story to me, so it's fascinating. Jared Jussim is the guy who is at the beginning of Jerry Maguire, who says, I love to get up in the morning, I clap my hands, and he does all this. And he's fantastic. And he said, I've only ever acted in one thing in my life, and that was it. And he said, the reason he got that part was they were using a lot of NFL pictures and stuff like NFL logos, all this kind of stuff, because Jerry Maguire has to walk through the lobby of the NFL draft. And he said he went to James L. Brooks's office, who was directing and written it and everything like this. And he knocked on the door, and inside was James Brooks and Cameron Crowe, who was the director and the writer. And he said, as he knocked on the door opened, and Billy Wilder walked out past him, because apparently Billy Wilder was originally meant to be the guy who does the clap my hands and everything like this. And Billy Wilder is very much a guy who wears a suit, wears a tie, turns up to work, like ready to go, on the set. And he apparently turned up and he saw Tom Cruise in a t-shirt and a pair of jeans. And he said, he's scruffy, I don't want to work on this film, apparently. So he walked out of the office just as Jared arrived, and Jared banged on the door. They opened the door, and he says, you can't use all this stuff. You're using the NFL logo here, using this, you're causing me an awful lot of problems and all this. And apparently James Brooks goes, here you go, read the first page of this script. And he read the first page of the script, and he went, you're our guy. You're our guy who does all this. And it's one of my favorite legal stories surrounding studios that I've ever heard. And Jared Justin, bless him, was the guy who told me that.
He was a sweetheart, and I totally get that story. If you knew Jared, he was that kind of a guy. Yeah.
Yeah, he brought me into this world. So I'm grateful to have met you and to have been able to expand on this, the legalities surrounding the studio system and surrounding films, everything like that. But Dale, thank you so much for talking to me.
Yeah, it's been an amazing conversation, Chris. Thanks again for having me.